Hello everyone, welcome to Law Grid. This is Chehek Pugalia and I'm here with Professor Dr. Ranbir Singh. In this video, we will be delving into the question of the new criminal laws which effectively came on July 1st, 2024. We all know that the earlier prevailing laws, which were Indian Penal Code, the Criminal Procedure Code, and the Indian Evidence Act, they all have been replaced by Bharatiya Nyaya Sanhita (BNS), Bharatiya Nyaya Suraksha Sanhita (BNSS), and Bharatiya Sakshya Adhiniyam, which is BSA, respectively. We have the person who has led the chair for this committee, which basically dealt and had reviewed the existing criminal laws and have brought a reform to the system and have introduced these three different set of legislations which were passed by the Indian Parliament. Effectively, they came into effect after July 1st, 2024. And we welcome you, sir, to the podcast.
Thank you, Chad.
Yes, sir.
Let me share some very important details with you. As you know, the penal code was Macaulay's penal code.
Macaulay's, yes.
So the Macaulay penal code, known as the Indian Penal Code, IPC, in brief, what you call it, was drafted by Thomas. What was his full name? Most of people will not know.
Thomas
First,
Macaulay.
The full name was Bemington Macaulay. Over time, do you know how many countries adopted the Macaulay Code?
No.
No. I think the students must know it. The Macaulay Code was adopted by India, Pakistan till 1973, Bangladesh till 1985, Sri Lanka, Malaysia, Singapore, Myanmar, which is Burma now, and then Kenya, Uganda, Tanzania, Zambia, Zimbabwe, Ghana, Nigeria, Mauritius, Seychelles, Fiji, Aden, now part of Yemen, and Hong Kong until 1997. And we have to note that many countries have replaced or modified or reformed these laws.
So these countries had adopted the same
Yes,
code,
yes,
Macaulay's
we
code.
must know it.
Okay.
And we should also know that many countries have now absolutely their own penal code. Like Singapore also has their own penal code. Hong Kong completely replaced the Macaulay's penal code. So now it is important to discuss this in the light of these events actually. And since it is more than 160-year-old code, Singapore did that exercise, and they had a huge international conference on what changes can be effected in the penal code which is there in Singapore. And then Singapore came with its own code. And since some of our people were in Singapore attending this conference, then we thought that why don't we also organize a conference like this? So in NLU Delhi, a conference was organized where professor like B.P. Pandey, who is a very known criminal law specialist in the country, he was a professor at University of Delhi. So he came to me and suggested, Dr. Singh, why can't we have this discussion? And I said, wonderful, this is a wonderful idea. So we said 150 years of the Indian Penal Code and the way beyond. This is how it started. And after some time we found that there was a kind of a circular from the Ministry of Home Affairs to the law schools, or maybe to other law faculties also, inviting proposals that we are thinking of reforms in criminal law in these three and more acts also, and will you send proposals? I'm sure people must have sent proposals. Since we recently did this exercise, we were the most competent law school to write on this. So we prepared a very comprehensive proposal, and we suggested that this is how we are going to do it. Sent it to the ministry, forgetting that
whether you'll get a reply or not.
We never bothered actually. And then suddenly there was a call from the Secretary of Home Affairs, and he talked to me and he said, the government has decided that we will request you under your chairmanship to draft or to change these reforms. What are the reforms you suggest? We leave it to you to choose your team, the members of the committee, and then send your proposal, and then we'll discuss and finalize
Yes,
the
sir.
kind of a proposal. So some people were chosen by the government, like Judge Thareja, who was a retired district session judge, was chosen. Then Mahesh Jethmalani was again chosen by the government.
Ram Jethmalani.
Ram Jethmalani's son. And then Professor Balraj was chosen by me, and Professor Vajpayee was also chosen by me, who was my registrar, and also a criminal law specialist. And that's how. And then there's some advisors. Professor Pandey was advisor. One Mr. K.P. Singh was an IPS officer and former DGP of Haryana. He was also chosen. He's a very academic person.
Yes.
So that's how this committee was formed, and the proposal was sent. The proposal was accepted, and then they said, you have to do it within 1 year.
Within 1 year.
It was a very difficult, very, very difficult task. And
so how much time Macaulay took to draft
I have no idea actually. And to surprisingly, one more thing I forgot to tell you, that actually initially this draft was not drafted by Macaulay.
Yes.
Macaulay
I think in 1857.
Macaulay requested one of the judge, who was a retired session judge that time, and his name was Sir William Macpherson.
Oh.
So he was requested. He prepared the initial draft, and the initial
changes were made by
initial draft was vetted by Macaulay, and there was another very important person, which the students of jurisprudence must know. Maine.
Henry Maine.
Sir Henry Maine was
Sir
also
Henry
there.
Maine.
Right?
Yeah.
So the Henry Maine was there, and that's how this was drafted.
Yes.
And when the government was accepted, the government accepted the proposal, and then we started the work. And the process was that we immediately got into action, and we drew a list of people those whom we need to consult, like the government agencies, like the chief secretaries of the states, the DGPs of the states,
yes,
and the governments and the BPRND and various wings of the government, or the other stakeholders, those who are there, and then the academics, NGOs, and then people also started criticizing the committee which was formed.
Yes, it was a five-member committee.
One criticism which I think was quite valid was, people wrote to me that why there is no female member, because they were all members were male. But then I said, for this you should write to the government, because I'm not the person to.
Sir, there is this one thing which has been cropping up. Usually, so I was on a call with one of my friends last night, and I was just telling about you, that I have a podcast scheduled with you tomorrow. And I told, and then he asked me, what's the topic? Criminal reforms and all. He's actually working at a big MNC, Intel. So, and he's a engineer, so software developer. And he was like, कौन से reforms? कौन से criminal reforms? People don't know that the highest, it is actually a big piece of legislation. It's not something that everybody should know actually. तो मैं बहुत ज़्यादा आश्चर्यचकित हो गई कि कल कॉल पे मुझे ये सुनना पड़ रहा है, और वो भी from a person who I consider literate. But ये क्यों है? मतलब awareness नहीं है, और बात नए criminal reforms की नहीं है, बात है क्यों नहीं पुराने रिफॉर्म्स के बारे में भी, पुराने कोड्स के बारे में भी पता नहीं है.
Many times, if you do not have anything to do with any kind of a law, probably you
just escape.
You just don't bother. How many multinationals will be bothered about the criminal law reforms, or the to some extent companies, or how much we are bothered about the competition law, or how much we are bothered about the insolvency law there, or maybe if you are not concerned with the labor law reforms, how you are concerned with the labor law reforms?
पर सर आपको लगता है कि एक आम आदमी को पता होना चाहिए?
To some extent, everything is not possible.
हाँ, to some extent भी, पर जो basic भी है,
basic laws तो पता होना चाहिए, because any law which affects your daily life or routine, I think that law people must be sensitized.
तो आपको उनको कुछ
हाँ.
कहना है जो जिन्हें बिल्कुल कोई
No,
आइडिया ही नहीं
actually,
है?
what is happening is that I may share with you that the NLU Raipur, the Hidayatullah Raipur, which we call it. Now they got into one MOU with the state government and also with the police department of Raipur to create training programs for the senior level officers of the IPS level, then all cadres, and I'm a part of it.
Okay.
I normally go there and participate in the inaugural
Yes,
of
sir.
those training programs, and it was started months before the criminal law reforms came in, right? Once it is implemented now, but the process already started. So the all states probably were given a mandate by the Ministry of Home Affairs that the training program should be started in the right earnest.
And when did it start, the training program?
I think it started immediately. Immediately started that the constabulary, the officials are aware of the new changes in the criminal law because since they have to effectively implement it, so this should be taken in right.
So you mean 2023 only they started?
It is already happening.
Okay.
It
is happening, but before it was drafted?
It happened after the approval of the obviously.
Yes.
Because then it makes sense.
Yes.
So suddenly after the approval, the process started.
Okay.
And almost every state is in some way, some are doing it very seriously.
Yes.
And on a very large scale.
Yes.
Some people are doing it not on a very large scale.
Yes.
But it is being done in each and every state.
Yes, sir.
And by and large, now a lot of literature has come. What were the old laws? What are the new laws? But surprisingly, I may share with you that 85 to 90% law is the same.
Yes.
Yeah.
Yes.
Not much changes have been. To the contrary, which people believe everything must have been changed except the name has been changed to the हिंदीकरण हो गया ना उसका.
हाँ, हिंदीकरण हो गया.
हिंदीकरण से थोड़े से लोग सोचते हैं कि भाई सब कुछ ही बदल दिया होगा. ऐसा नहीं हुआ है.
हाँ.
तो उसमें ये है कि बस probably that could be avoided. I don't know because we did not change it.
अच्छा, पर सर वो एक्चुअली इस पे भी बहुत क्रिटिसिज्म था कि
because southern states may have regulations
problems
because there was nothing wrong with Indian Penal Code or CRPC or Indian Evidence Act. It was all right, but the government in its own wisdom thought कि हिंदीकरण कर दें तो शायद अच्छी बात होगी. But I don't know. But to that extent I can criticize that it was not a good idea.
हाँ. तो आपको नाम सोचने में like is there a story behind that you want to share in नाम के
Actually
पीछे?
No, we suggested the same. We did not even for us it was a surprise. Even for us it was a surprise that we also took some time to understand. Okay, what are these names? Because initially it sounds very technical.
Technical, yes.
It is a technical Hindi kind of thing.
So, but I think with time people may get equipped.
We get used to this.
Yes.
And probably this is what they thought. But I should also share with you, but the basic idea was very laudable in the sense that our constitution came up 75 years back, and these laws were 160-year-old. So there was a very strong undercurrent going on that we should make these laws compatible with the
Indian framework,
like fundamental rights or the directive principles of state policy. A lot of judgments were there. So these laws were not compatible with many of those constitutional values. So one was that, and it was in that light that reforms were long overdue.
So, sir, what are the major reforms that your committee has suggested and drafted? Were there any difficulties when you were drafting?
The difficulties will obviously.
The technicality.
Technicalities was there because, as I said, two important factors which were there was to make it more constitutional friendly kind.
Constitution.
Right.
Yes.
And the second was to look into the technological changes.
That is actually the major impact.
That was the major impact.
Yes.
So those were the two basic factors which led to the changes in the criminal law, and they were laudable, I will say.
Yes, they are definitely laudable.
Certainly laudable, but as Ambedkar said, that any constitution would be good if people implementing it are good, and any constitution will be bad if the people implementing it are not that good or bad.
Yes, sir.
So result will depend on that. So to this extent also I say, to make these laws more successful, two very important things which I think should be immediately done are SOPs, the standard operating procedures, and the rules and regulations. Especially when you bring in forensic evidence, to that extent, rules and regulations have to be framed. Like you also create forensic labs. So unless and until rules and regulations are there, you will not be able to implement these laws. These are
सर
certain.
बहुत लोगों को जो अभी हम बात कर रहे हैं आई गेस it will just go above the head because they may not even know what it is, what this BNSS is. So can you just, like, in few words, in layman language, can you just explain what are these three different piecemeal legislations?
Listen, Indian Penal Code, CRPC, and
No,
Evidence Act. That's it.
what is the nature? What does it do to them? What is like IPC is basically the substantive law.
What is the offence and what is the if some offence has been cut?
Yes, so in
then,
that chain, yes.
And then if the offence has been committed, what will be the punishment like? That is the IPC. And what procedure will be followed for that kind of thing? Procedure for arrest or bail or whatever. That was CRPC. And evidence is evidence.
What are, yes.
What you call it in the, what adhiniyam is that?
Yes.
Even I find difficulty
yes.
pronouncing it.
So we have these three laws. Yeah. So IPC, which now has become BNS, Bharatiya Nyaya Sanhita, it lists out all the offences which are punishable under the code. So initially it was Indian Penal Code, now it is Bharatiya Nyaya Sanhita. So it is a substantive law. Now CRPC, which was Criminal Procedure Code, but now it has been replaced by Bharatiya Nyaya Suraksha Sanhita. It lays down the procedure once the offence is committed. That first information report file होगी तो कैसे file होगी, या bail का procedure क्या है, warrant case में चीज़ें कैसे होगी, summon, plea bargaining, ऐसे करके बहुत सारे sections है जो procedure से related devolve करते हैं. And then we have the Indian Evidence Act, now replaced by Bharatiya Sakshi Adhiniyam, which talks about कि कौन सा evidence admissible है court में, जिसमें अभी बहुत ज़्यादा changes आए हैं, which sir has said.
Digital component ले आए हैं.
हाँ sir, so 85% has remained the same, and the 25% which you told कि जो दो aspects है कि constitution friendly जो digitize करनी थी पूरी evidence की, so these reforms, in your view, are these reforms real in nature? Like, to what extent these reforms are effective as well?
See, technological reforms, because of the technical changes, are certainly a very welcome step.
Yes.
Because since these laws were drafted 160 years back, these changes were not anticipated at the time.
Yes.
So the laws have to be in tune with the changing circumstances of the time.
True.
So to that extent, they have certainly served their purpose.
Yes, sir.
These reforms were actually required.
Sir, जब 1 जुलाई 2024 को पहला केस इंस्टीट्यूट हुआ था, I don't know if it was theft or robbery, theft था शायद पहला केस रजिस्टर हुआ था, तो people had these questions which were cropping up कि 1 जुलाई के बाद से न्यू क्रिमिनल लॉज इफेक्टिव होंगे, तो ये एक कंफ्यूजन कि 1 जुलाई 2024 के बाद ओल्ड लॉज प्रिवेल करेंगे या न्यू लॉज प्रिवेल करेंगे, क्या इससे जुडिशरी पे बर्डन आएगा, तो उस चीज से मतलब व्हाट इज योर आंसर?
I don't think there will be any tangible burden either on the police or the judiciary. Slowly things will settle down.
Okay.
I think there's not so much of उसमें कोई chaotic situation नहीं होगी.
सर, कोई ऐसा प्रोविजन है जो स्पीडी जस्टिस के लिए कंट्रीब्यूट करता है?
Actually, yes, you are right. Some of the basic parameters for changes in law was that we should look into the federal aspect, look into the constitutional values, you look into the pending cases, so that one of the main aim of these reforms was also to go for speedier justice.
और सर ये
So,
कैसे होगा?
because of the
हाँ.
technological involvement of the
Hmm.
in the criminal justice administration system,
Hmm.
and also to probably to some extent reform the lodging of the FIR and the how the cases in criminal law cases will proceed, those kind of things.
सर जो इन्वेस्टिगेशन प्रोसेस है वो आई थिंक अब लिमिट हो उस पे एक लिमिट आ गई है.
I think some timelines have been given.
Yeah, so on the provisions
That
there
will
has been.
that will also help.
Yes, sir.
Yeah.
So, sir, वो आप viewers को बताना चाहेंगे कि these provisions have helped and they are in tune with the.
Yeah, this I said in the beginning also, that the very idea of taking these reforms was to make them more constitutional friendly,
Yes.
and to make them all technological friendly. And these two aspects have been well taken care of by the reforms of the what reforms have been introduced in the criminal law, and I think it's a welcome step.
Sir, आप कुछ बोलना चाहेंगे?
Thank you very much for this wonderful interaction with you, and I think it will be very useful for
everybody who is watching.
For everybody who is watching this program. Thank you very much.
Thank you so much. Please do watch this video at a full length. If you need more queries on the same, please drop a comment in the comments box, and we will definitely look into it, and the same will be shared by Professor. Thank you so much, sir.